by the committee. Thank you.
Resuming debate, the honourable member for Cowichan-Malahat-Langford.
Thank you, Mr. Speaker. It's a great honour to rise today to take part in this very important debate on Bill C-22. I feel very honoured to be able to give voice to the serious concerns that many of my constituents have in the great riding of Cowichan-Malahat-Langford. I also want to note that this debate is taking place under the yoke of time allocation, Mr. Speaker. In other words, the ability of parliamentarians to provide oversight on a bill dealing with oversight has now been curtailed by the government. Bill C-22 cannot be debated without being properly placed in the context of C-51 from the 41st Parliament. C-51 was one of the most draconian pieces of security legislation to emanate from the previous Conservative government, and indeed more than 100 of Canada's brightest legal experts from institutions across the country sent an open letter to all members of Parliament at the time expressing their deep concern about Bill C-51. They called that bill a dangerous piece of legislation in terms of the potential impacts on the rule of law, on constitutionally and internationally protected rights, and on the health of Canada's democracy. We had former Prime Ministers, former Justices of the Supreme Court of Canada, and all sorts of experts who gave close scrutiny to C-51 and were convinced it was unconstitutional. Many of my constituents were very vocally opposed to Bill C-51, and indeed many of them took part in the protests that erupted right across Canada during that time. It was a sad day in Parliament when the Liberals joined with the Conservatives to pass that bill. I think, Mr. Speaker, and many of my colleagues will agree with me that at that time on C-51, the Liberals were indecisive, they were unreliable, and they were just plain wrong to support it. But I think at the time they didn't really realize how much of a serious misjudgment they had made with the Canadian public, the Canadian mood, because when we edged closer to the 2015 election, we suddenly saw a commitment in the Liberal campaign platform to introduce new legislation that would basically balance collective security with our rights and freedoms. And part of that promise was to establish an all-party national oversight committee, which we see today in Bill C-22. Now, Mr. Speaker, in our system today, we have a history of having opposition chairs in oversight committees. As ethics, public accounts, status of women, and government operations all have permanent elected opposition chairs to ensure proper accountability and oversight. It is most unfortunate that the government has, through Clause 6 of the bill, provided for the Governor and Council to designate the chair of the committee. And in fact, the government hasn't even bothered to wait for the passage of this bill because, as we all know, it's been widely reported that the member for Ottawa South is to be the chair. The government has also rejected attempts at the committee stage to allow for the committee to elect its chair, something which I think is very unfortunate. Mr. Speaker, if I can deliver one message today, it's that Canadians expect to have a watchdog, an oversight committee that has real teeth. I think that this committee must have full access to classified information, it must have adequate resources, and most importantly, it must have the independence, subject only to justifiable limits, to have the power to share its findings with Canadians in an informative and transparent manner. Without adequate access to information, the committee simply won't be able to do its job effectively. I think this work is far too important to do half-heartedly or ineffectively. I will not support creating a committee that cannot properly provide oversight in accordance with what Canadians expect. Now, one of the government's proposals is to allow cabinet ministers to withhold information from the Oversight Committee. This is evident in Motion 5, which the government has presented, which seeks to reinstate Clause 16, worded in a way that allows a minister to withhold information if he or she feels that it is special operational information or that the provision of the information would be injurious to national security. Now, injurious to national security, if that isn't a blanket statement to cover any kind of reason, I don't know what is. And yes, I have heard Liberal MPs say that, there is a proper accountability and oversight because the minister simply has to inform the committee of his or her decision and the reasons for it, as if that somehow makes everything okay. I cannot support such a reinstatement of that clause. I think that the Public Safety Committee and the experts that were heard made it very clear that having the executive branch have this kind of power over an oversight committee simply will not fly, and it will simply make the committee completely ineffective any time a minister wants to withhold the information. I think as the way the government wants to write the bill, the minister can somehow claim that a confidential inquiry somehow jeopardizes the country's national security. And I really think, Mr. Speaker, that giving the government the ability to shut down any kind of investigation into their actions is too dangerous for a functioning and accountable democracy. The other thing, Mr. Speaker, is that we need to build Canadians' trust in our security and intelligence community. And the way to do that is to create meaningful parliamentary oversight. We need to have a fully briefed parliamentary oversight committee that can issue authoritative reports to Canadians. And I think that without full access and full trust from the agencies, the Oversight Committee can't help those agencies earn Canadians' trust. It is very disappointing and frustrating that the Liberals are not living up to the commitments that they made trying to fix Bill C-51. I think that to rebuild this trust, the committee must be strong, independent, and effective. I think that the Liberals must fulfill their promise to, quote, repeal the problematic elements of Bill C-51. I find it very troubling, Mr. Speaker, that the government cannot seem to place its trust in a very select group of parliamentarians who will be security cleared, sworn to secrecy, and who have waived all immunity based on parliamentary privilege. To underline just how ridiculous this premise is, I would like to point out to all honourable members in this House that there are members of the Conservative Party here in opposition who were once members of Cabinet in the previous Parliament. They at that time had access to all kinds of sensitive information and are still bound by secrecy. Why the government will not now trust this committee to have full access and provide proper oversight still remains an elusive mystery. Mr. Speaker, all parties worked hard during the committee process to improve Bill C-22, and the final product, as was reported back to this House, was praised by 4 of Canada's leading authorities on intelligence and oversight issues, who wrote a joint op-ed in the Globe and Mail calling on the government to accept the improvements and pass the bill. The last-minute changes the government is now trying to make are unsupported by evidence heard at the committee, and they would undermine the effectiveness of the committee and the trust of Canadians. The Information and Privacy Commissioners of Canada, Kent Roach and Craig Forsisi, the first chair of the Security Intelligence Review Committee, and the Canadian Bar Association of Canada all testified that the Oversight Committee should not be restricted in its access to necessary information. I do not understand why the government is attempting to reject that expert evidence. Mr. Speaker, there are 3 core agencies responsible for security and intelligence work in Canada: CSIS, CSE, and the RCMP, and they have a combined budget of approaching $4 billion, and they employ close to 34,000 people. Clearly, such a vast network needs to have the accountability and oversight of Parliament in order to regain Canadians' trust. Mr. Speaker, the role of Parliament is to scrutinize the government, represent the Canadian people, and to bring forth good laws to govern our people. I call on the Liberal MPs sitting in the back rows to go back to that special day on March the 8th during the vote of Bill S-201, when they had the courage to stand up and assert their power as legislators in the face of the opposition from Cabinet. Just as they did then, those Liberal MPs should reject the government's 11th-hour amendments to this bill and instead listen to the evidence that was so clearly presented to the Standing Committee on Public Safety. I ask all MPs in this House to remember that the government is accountable to Parliament, not the other way around. Thank you, Mr. Speaker.
Questions and comments? Question commentaire? The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. I appreciate the comments from the member. Disagree with a number of the points. At the end of the day, Mr. Speaker, I was there when there was a great deal of opposition to C-51. The Liberal Party was different than the NDP back then because we believed that there was a need to see C-51 get passed ultimately because of a wide variety of reasons. The security of Canadians was the predominant one there, but we also made the commitment back then that we would bring in the parliamentary oversight. This bill does just that. My question to the member is that when we take, and I've been a parliamentarian now for 25 years, about 25 years, I know how committees work. And at the end of the day, I believe in the integrity of the members of Parliament that will make up that particular committee. A majority of that committee will not be held by government members of Parliament. The government members of Parliament will be a minority. That means that it would take others to be on side in order to get something passed through. So does that not provide any reassurances whatsoever to members across the way, Mr. Speaker?
The honourable member for Cowichan-Malahat-Langford.
Well, Mr. Speaker, in a short answer, no, it doesn't, because I think, yes, I appreciate that members of the governing party on the committee may not have a majority position, but if the member had correctly listened to my speech, I don't really care about that particular section. Mr. Speaker, my main concern is the clause in clause 16 of this bill, which still allows a minister with this blanket provision to keep information from that committee. So no matter what the membership of the committee is, the problem is not solved if you still have a clause allowing a minister to withhold information. And we need proper oversight, we need proper accountability. And I don't know what the government's problem is when you have parliamentarians who are sworn to secrecy, have received security clearance, and basically have waived their right to parliamentary privilege. So they will be accountable, fully subject to the law if they break that secrecy. I'm not sure why the government can't trust those parliamentarians when there are members in this House who used to be members of the previous Conservative government are still maintaining that oath of secrecy. I think what the member is talking about is window dressing. He did not address our real concerns to this bill.
Questions and comments? Question commentaire. The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and I thank my honourable colleague from Cowichan-Malahat-Langford for putting it so very clearly about the concern of why is it that this parliamentary committee of MPs and senators, with all of the stringent qualifications that they will have to undertake to be members of the committee, should have information withheld from them. I mean, I do plan to vote for C-22 because I think it's important to have parliamentary oversight. We've never had it. But I am still putting forward my own amendment, which I hope the honourable member will support, to delete the section of the bill which removes parliamentary privilege from MPs. Other countries with parliamentary oversight of intelligence operations do allow their MPs to continue to have parliamentary privilege. I see that one deletion as a way of pushing back on the overall message from the government here that MPs are not trusted with information.
Honourable member for Cowichan-Malahat-Langford.
Well, Mr. Speaker, I thank my honourable colleague from Saanich Gulf Islands for that part. I mean, I am still examining her proposed deletion of Clause 12 because I think that in our system of checks and balances, in order to afford parliamentarians that privilege of accessing this information, I think there do need to be some checks. But I don't think the government is going to accept that in any case. And so one of the important amendments that my colleague from Victoria has moved is the deletion, I believe, of Clause 31, because we hope that if the government's going to reject everything else, we hope at least that by deleting Clause 31 in this bill, we can allow that accountability to a federal court, because we know that certain federal judges are sworn to secrecy. They deal with very sensitive information on ongoing operational bases, and sometimes they have to issue warrants with very sensitive information. So we hope that at the very least, by eliminating Clause 31, we have that recourse to the courts to actually enforce some of the things that the committee is trying to do.